Hello, my name is Ashley Arnold, and I'm the Vice President of U.S. Drug Test Centers. Today I'm going to be talking about the Federal Motor Carrier Safety Administration, also known as the FMCSA Clearinghouse, specifically for DOT employers. Now, the Clearinghouse was released in January of 2020, but let's go back and discuss how the Clearinghouse first started. So the Clearinghouse rule was originally published in December of 2016, but it did not go into effect until January 6th of 2020. At this time, the Clearinghouse began to affect FMCSA-regulated employers and their safety-sensitive drivers. But the Clearinghouse now replaces the requirement to contact previous employers with a paper form to check on any drug and alcohol testing violation history of an employee that you may be hiring for a safety-sensitive position or as a safety-sensitive driver. This program has now been into effect for about 3 years. But as I previously mentioned, there's no previous employer contact required now. However, it is required that you perform a query in the Clearinghouse. Now, a query is something similar to a background check. However, it will provide you with information specifically related to drug and alcohol violations. For example, a positive drug test or a refusal to take a drug test or an alcohol test. The query will also tell you whether or not an employee is in a prohibited status. Now, if they're in a prohibited status, you are not authorized to hire them for a DOT FMCSA safety-sensitive position until they take the proper steps to remedy the violation. This will include the completion of a DOT-required substance abuse program and to have a negative observed return to duty drug and/or alcohol test and ongoing follow-up testing. Now, there are various employer responsibilities that are required by the FMCSA Clearinghouse. One of them being conducting queries, as we just mentioned. So first, employers are required to be registered with an FMCSA Clearinghouse account. The employer is the responsible party that must conduct a pre-employment query on all new employees that they are hiring or that they are going to be moving into an FMCSA safety-sensitive position, which would be a CDL driver that's operating a commercial motor vehicle on commercial roads. Now, in addition to that pre-employment query, all FMCSA safety-sensitive employees must have an annual query conducted by the employer within a 365-day period. This includes all existing CDL drivers that are currently enrolled in the employer's random drug testing pool as well. Now, query plans are available for purchase by the employer in their employer clearinghouse account. The FMCSA does charge a fee of $1.25 per query, and a query plan must be purchased before queries can be conducted. Now, when you run a full query, which is typically used for pre-employment, your driver is going to receive an electronic consent form in their driver clearinghouse account, and they will give consent for that query to be run. The electronic consent form is generated from the FMCSA Clearinghouse system, and that driver will only receive an email stating they need to provide a consent to a query if they are registered as a driver in the FMCSA Clearinghouse. Otherwise, the consent is provided through the regular mail, and there's a limited query that can be conducted. The electronic consent form is generated from the FMCSA Clearinghouse system. Now, the driver will only receive an email stating that they need to provide the consent to a query if they are registered as a driver in the FMCSA Clearinghouse. Otherwise, the consent will be provided through regular mail. Now, there is a limited query that can be conducted, and this is typically used for annual queries, which are conducted within a 365-day period for all FMCSA safety-sensitive employees operating for your company. Now, electronic consent is not required for annual limited queries to be conducted. A paper consent form can be used instead. Limited queries will inform the employer, though, if a safety-sensitive driver has a drug and/or alcohol violation on their record. If the limited query reveals that there is a violation, it will be changed to a full query, though, where the driver must log into their clearinghouse account to respond to the full query and complete that electronic consent form. Once a consent form is provided for the full query, though, the employer will be able to review that violation detail on their employer clearinghouse account. Now, the employer is also required to report certain violations for FMCSA safety-sensitive employees. These violations also include positive breath alcohol tests, which are those that are above 0.04 breath alcohol level or above. Alcohol testing is administered using a breathalyzer, and the breath alcohol level correlates to the breath alcohol test. Now, the breath alcohol technician that administers the alcohol test should be reporting these positive results directly to the employer. It's then the employer's responsibility to report that positive alcohol test back to the clearinghouse. The employer is also required to report employer-determined refusals for drug and alcohol testing to the clearinghouse. Now remember, a refusal is a violation that is just as serious as a positive test. So typically, employer-determined refusals are when an employee refuses to go in for testing, or they do go in for testing and something happens at the collection site where they don't stay for the completion of the collection. The information provided back to the employer gives the employer the information that they need to make an official determination of a refusal to test. It is the responsibility of the employer to report that as a refusal. If any of these violations are reported to the clearinghouse, the driver will be required to complete a return to duty process, as we discussed earlier. The DER, or the designated employer representative, is required to remove the prohibited driver from the safety-sensitive position, and they should be provided a list of substance abuse professionals, or what we call a SAP. The SAP helps the employee go through a process of return to duty. Now, part of that return to duty process is a negative return to duty test. The employer has the responsibility to report the negative result of that return to duty test to the clearinghouse, which will then allow the employee to return in a DOT safety sensitive position. The employer must also report the completion of all follow-up tests required by a substance abuse professional as part of the return to duty process. So it is important that they do not report each test that is completed, but it's the actual completion of all follow-up tests that gets reported to the clearinghouse. So for example, the substance abuse professional or the SAP may be requiring 12 follow-up tests over the next 2 years. The follow-up testing would only be reported after these 12 follow-up tests has been completed at the end of those 2 years. Employers should be providing policies and educational programs to notify drivers of what information will be reported to the clearinghouse. This has always been a part of what employers are required to do. Employers should also provide drug and alcohol testing policies to all employees, as well as education about those rules and regulations and the harmful effects of drug and alcohol use in the workplace. Now, the medical review officer, or the MRO, also has a specific required responsibility for clearinghouse reporting. Primarily, the MRO reports to the clearinghouse any positive drug test results. So the MRO must also report to the clearinghouse any refusals to test that are determined by the MRO. Now, typically the MRO determines refusals when a lab result for a urine specimen is deemed adulterated or substituted by the laboratory. Back to employers, the employer is also required to report situations of actual knowledge of drug or alcohol use while working in a safety-sensitive position to the clearinghouse. Now, actual knowledge is not reasonable suspicion. It is specific evidence that a driver has used alcohol or a controlled substance while performing their FMCSA safety-sensitive duties. What is not actual knowledge? That would be something like a DUI on personal time in a personal vehicle reported from a coworker of the drug use or alcohol use. That is not actual knowledge. Reasonable suspicion is based on signs and symptoms. If there's reasonable suspicion based on signs and symptoms, you can then order a reasonable suspicion test for that employee, but this would not be covered under actual knowledge. So other things that could be covered under actual knowledge would be, is the admission of use of drug and alcohol actual knowledge? A DUI while operating a commercial vehicle while working. Actual knowledge is a direct observation of the use of drugs or alcohol while actively working in a safety-sensitive position. And again, with actual knowledge, it is a violation. So the only time when a negative result will be reported to the clearinghouse is when reporting a negative return to duty drug and or breath alcohol test. The substance abuse professionals, or SAP as we call them, also has responsibilities for reporting to the clearinghouse. So a substance abuse professional will report the date of the initial employee evaluation once it's completed and a date of eligibility for return to work. So the SAP has no other reporting requirements other than the date that the completion of the initial evaluation is done and the date of eligibility to return to work, which is going to be at some point after the final evaluation. So information about the clearinghouse should be included in an employer's drug and alcohol testing policy and should be included in employee education materials that are required to be distributed to the employees that are in an FMCSA safety-sensitive position. So as an employer, how do you accomplish these employer tasks? How do you make sure you're in compliance with the FMCSA? How do you avoid liability? How do you avoid fines and penalties? You can try to do it all on your own, but you can also get professional expert advice from a consortium or a third-party administrator. A professional company like U.S. Drug Test Centers can help you with all aspects of compliance related to the FMCSA Clearinghouse. So as the employer taking some initial steps, if you're not registered, ensure your registration is completed immediately to ensure your company is in compliance with the FMCSA. Also, require your existing and new drivers to get registered as well. Ensure you are conducting the required queries for existing and new drivers. Remember, you will no longer need to do this on paper or previous employer checks. Now that we've discussed the clearinghouse requirements and responsibilities of employers and other parties, it is also important to know that a third-party administrator or a TPA can manage employer responsibilities, such as reporting positive breath alcohol results and refusals to test on the employer's behalf. At U.S. Drug Test Centers, we manage all these responsibilities for our FMCSA clients. U.S. Drug Test Centers can help you with running your required pre-employment and annual queries, reporting employer violations, reporting return to duty and follow-up test results, and things of those nature. You can contact us at U.S. Drug Test Centers for assistance at 866-566-0261, or you can also go to our website at usdrugtestcenters.com, where you can review important clearinghouse information and clearinghouse management services. A list of FMCSA clearinghouse violations are also available to read on our U.S. Drug Test Centers website. Lastly, call U.S. Drug Test Centers and get expert assistance today. Stay in compliance, avoid fines, and avoid exposure to liability. Thank you for taking the time to learn this important information that will help your company and your employees stay in compliance with the Department of Transportation.